Lauren Mulrain back with you here today. A few years ago, several years ago, in fact, I did an audio book called The Course, and it was looking at some general areas of copyright law. And the goal always was to develop that into a series, which for various reasons I never got around to doing. But this year, as I started teaching my copyright law course, I decided this would be a good time to get back into the course and create a series of video lessons that break down copyright law. I'll eventually do it for the other classes, the other courses that I teach. But this section right here is just on copyright law, and we're calling it the course Copyright Law Part 3. So in this week's episode, we're going to be looking at some things that deal with the limitations on copyright protection. We already know that copyright gives some certain protections to the authors, the creators of works, that allow them to monetize and to protect their work and to prevent other people from doing certain things with their works. But along with those protections comes some limitations. There's certain things that you can't get protected by copyright. And Section 102B of the Copyright Act actually outlines or lists some various areas that cannot be protected by copyright. Those include ideas, processes, procedures, systems, methods of operation, concepts, principles, or discoveries. These are things that cannot be protected by copyright. They may be protectable by other types of intellectual property protection, such as patent or trademark, but you cannot copyright them. So that's our starting point. Now, this week we also looked at some things that, maybe they can be copyrighted in certain instances, depending on how you express them. Remember, we talked about copyright going to the original expressions of an author. So what exactly is it that the author is attempting to express? One of the things that we looked at this week was facts. Facts. Can you copyright facts? Well, the short answer is no. Facts are not copyrightable. However, in certain instances, the creator, the author, might be adding some original expression or some original arrangement to how these facts are outlined. And if that's the case, there may be copyright protection. Now, of course, that copyright protection would only extend to the original elements of the expression, not to the facts themselves, right? So a number of cases we looked at this week included the Feist v. Rural case, Nash v. CBS, Holding versus Universal, all of which dealt with this area where the creator is putting together some kind of compilation of factual information or factual data, and then someone else comes along and wants to use that data or that information in their own work. And naturally, there is a disagreement between the two parties on whether or not that can be done. And ultimately, in each of these cases, what we found out was the facts themselves cannot be protected. But if you have an original expression or original arrangement, your selection and arrangement of how you put these facts together, maybe you're adding some original elements as far as how you analyze the facts, right? That original analysis might be something that is protectable by copyright, in which case you can stop someone from using it in that manner, but you would not be able to stop them from using the facts themselves. One of the things that we talk about with copyrightability of both compilations and derivative works, in fact, is that your copyright in the new work, your copyright in the new compilation, for example, has no effect on the copyright status of the original work that you are using. So if that original work that you are using or those original works you are using were copyrighted and are still copyrighted, they still have their own copyright. The compilation, if you've got original expression in there, would have its own copyright or original arrangement. You'd have your own copyright in that, provided that it's not violating someone else's works. Now, in the case of compiling facts, obviously you wouldn't need to get permission from anyone to use those facts in your new work because the facts themselves are not copyrightable. Your expression, though, how you order them, how you outline them, what original things you say about them in your analysis or your expression, that would be where you are allowed to get some sort of copyright protection. If historical theories are treated as fact, then they are not copyrightable. We had a couple of cases where we looked at that instance where, someone came along, they looked at something that had happened historically, maybe it had not been expressed before. They created an expression of this historical event, and they expressed it as being factual. This is what happened, and I'm presenting the facts to you. Someone else comes along and wants to use that book or that story and tell the story themselves, you can't bring a copyright infringement suit for them for using that information because it was presented as fact, historical information presented as fact. That would be totally different if you had it presented as fiction. We've heard of historical fictional works, in which case it really is all about the expression and the new characters and new storylines and imaginations that you're bringing to some historical event. So that would create a totally different outcome in that case. Now, you can get copyright for selecting and combining them in an original way. You cannot copyright what we call scenes of fare, or standard storylines or concepts, or stock or standard literary devices, or stock plot lines. Boy meets girl, boy falls in love with girl, girl falls out of love with boy. They go on their merry way and then come back at the end and get fall in love again. Well, that's a standard plot line that you see in every rom-com, right? Or even back to ancient works of literature. That's a standard plot line which you would not be able to protect. What you might be able to protect is the story that is original, but not the standard plot lines. Now, we also talked about the copyrightability of characters, because quite often when you're looking at stories or you're looking at shows or movies, they're made up of characters. So the question will often come up, can I copyright the characters that are in this story? And there are actually two tests that are available to provide for copyrightability of characters. The first one is whether or not the characters are well delineated. And we'll talk about that in a second. The other test is whether or not the characters are, quote unquote, the story being told. If they're the story being told, they may be eligible for copyright protection. So what is a well-delineated character? We can think about this in the context of what is it that makes the particular character unique? Does this character have a certain persona that's been defined in the story? Do they look a certain way, walk a certain way, talk a certain way? Do they have interpersonal relationships that are the same based on their persona? These are things that might create a well-delineated character. Think about James Bond, right? A well-delineated character. Think about in the 90s sitcom Seinfeld. Think about Kramer, a well-delineated character. What about Rocky, the Rocky movies? We had very well-delineated characters in the Rocky movies, right? So you could, in those cases, copyright the characters. What does that mean to the copyright owner? It simply means that if someone else comes along and wants to use those characters in another story, they would need your permission, or they would be violating the copyright in the characters. Now, what about that second test? Copyrightability of characters based on the character being the story being told. One of the recent examples that I think would fit nicely into this area would be there's a Netflix limited series called The Queen's Gambit. Great piece that I enjoyed watching recently. And the star of this series is originally a little girl who was an orphan and becomes a chess prodigy, and she's followed throughout her years as she becomes a world champion in chess. And this character is the story being told. It's not so much the delineation of the character, her characteristics, or of her look or her sound or anything like that. It is the fact that she is the story being told. So in that case, it would be likely that the author would be able to rely on that as a copyrightability for the character, for the lead in the Queen's Gambit. That's just a recent example. Now, the other thing that comes along with developing whether or not we can copyright some basic things that are maybe factual or not really well developed or terribly unique is something called the merger doctrine. Now, the merger doctrine applies whenever you have a work that can only be expressed in one way or a limited number of ways. If there's only one way to express something, or a very limited number of ways to express it, then merger is said to have occurred. That is, the idea and the expression are merged into one. And if that is the case, then you will not be able to receive copyright protection for that work. The policy consideration behind that is that if we were to allow you to copyright something that can only be expressed in that one way, we're basically giving you an unreasonable monopoly on this particular thing. The classic example, one of the cases the in the casebook that we looked at this week, is the sweepstakes rules. Right? If you've ever seen these sweepstakes where you enter to win, $1,000, and they give you instructions on the sweepstakes form, and you have to fill out your name and your address and your phone number and your age and so on. And they tell you what eligibility rules there are. Well, there are only a certain number of ways you can express sweepstake rules. That's not something that you can be very creative with. And so the actual language of the sweepstakes rules would not be copyrightable. What else might be falling into that categorization? Well, forms. Blank forms, what we call blank forms. Think about this. You go to a doctor's office, and when you first get there, they give you a bunch of forms on a board that you're supposed to fill out. And these forms ask for various things from you: your name, your age, your health background, any kinds of challenges you've had, or your family health history. These are forms for medical service. And those forms are not copyrightable. Why? There's words on there, right? There are words on there, but they're not copyrightable because they are not conveying information. They're simply asking you for information. So those are considered blank forms and would not be copyrightable. Another example would be forms that are used in accounting, right? And they ask for you to do certain things in order to get a response on the accounting form. Those would be considered blank forms and would not be copyrightable because they do not convey information. What about computer programs? Computer programs are copyrightable and have been found to be copyrightable as literary works. Literary works. They are writings of the author that can be perceived either by the human eye or with the use of some aid of some device or machinery. So they are copyrightable as literary works. How about useful articles? If you have an article that is a utilitarian article, and it's a fancy utilitarian article, the person who created it might seek to get copyright protection for it. The question that comes up in those cases is whether or not this useful article has artistic merit in and of its own right. It's something that we call conceptual separability. And conceptual separability simply says that, or simply asks, can it be identified separately as an artistic work? This thing here that is a useful thing, can it be identified separately as an artistic work? Major v. Stein is one of the seminal cases in this area where there was a statuette, a beautiful statuette that had been turned into a lamp. Someone else comes along and wants to make a copy of the lamp. The owner of the lamp design sues for infringement. The defendant says, this is a utilitarian item. You can't copyright this. It's a useful article. The court says, well, it's being used in a utilitarian way. However, its artistic merit stands alone. You can look at this thing and see that it is a work of art. It just happens to be used in this context as a lamp. So what you would really be looking for at that point is whether or not when you look at this thing, you can actually imagine it, or you envision it, not imagine it, but you envision it as its artistic work that it is. Here's something that I would use as an example. I bought this at this is a little bass player figurine that we bought either at, I think it was either at the Schermerhorn Concert Hall or the Ryman, where we were there for an event. And this is clearly just, a statuette, a work of art. But imagine if this actually was a drink coaster, right? We've got a little platform here, and you could place a glass on it, and it'll protect your table from getting, wet. And you're using it as a coaster. Well, that makes it a utilitarian work. But the fact that it's a utilitarian item does not take away its artistic merit. You can clearly look at this and say, this is an artistic work that can stand alone and would be then worthy of copyright protection, even though it has a utilitarian function. Question is, would the feature for which copyright is claimed have been eligible for copyright protection as a pictorial, graphic, or sculptural work had it originally been fixed in some tangible medium other than a useful article before being applied to a useful article? That question really comes from the case, the most recent case that we looked at in this area involving cheerleader uniforms and the designs that are on these uniforms and whether or not those designs could be copyrightable. And ultimately, the court found that they were copyrightable because they stood alone as artistic works and could be copyrighted outside of being used on that useful article. So you really asking yourself, what do you see when you look at this item? Do you see some artistic merit that is separate from the utilitarian purpose? If so, then a copyright would be appropriate in that case. And finally, there's a little bit of discussion in this area on architectural works. Architectural works are, in fact, protectable by copyright. There are some limitations with regard to, you cannot stop someone from taking a photo of an architectural work, provided that the building is in a public place. And there's limited protection over others making unauthorized use of the plans. But in general, architectural works are, in fact, copyrightable as well. So that's all we've got for part 3. Our next part's going to be really interesting because part 4 of copyright deals with copyright infringement. How do you prove infringement when someone comes along and allegedly infringes upon your copyrightable work? So I look forward to seeing you next time for the course Copyright Law Part 4. Take care.